right. It looks like we have a quorum, and I would like to go ahead and welcome everyone to the, what meeting is this? Meeting 2 of the Interim Joint Committee on Health Services. And we have a robust agenda today. We're going to go a little bit out of order, but just a few announcements. If everyone could please silence your cell phones. And we will go ahead and call the meeting to order. DJ, please take the roll.
Senator Adams, Senator Berg, Senator Carroll, Senator Douglas,
Present.
Senator Herron, Senator Mills, Senator Nemus,
Present.
Senator Rawlings,
Present.
Senator Richardson, Senator Tishner, Representative Bratcher, Representative Bray, Representative Burke, Representative Callaway,
Present.
Representative Camuel, Representative Dotson, Representative Duval,
Present.
Representative Fleming, Representative Gordon, Representative Holloway, Representative Marzian, Representative Neighbors, Representative Proctor, Representative Rayburn,
Here.
Representative Raymer,
Here.
Representative Riley,
Here.
Representative Sharp,
Present.
Representative Wilner,
Here.
Co-Chair Meredith,
Present.
Co-Chair Mosier.
Here. Okay, we have a quorum established and are duly constituted to conduct business. I, again, welcome everyone. And the first announcement that I would like to make today is, and we have a few members who are going to have to leave early, so I wanted to make sure that everyone was here to say thank you to Deanne Wank, who has been our health expert and the director of Health Services Committee for as long as I've been here. I have had the distinct honor and privilege of sitting next to you for 10 years. Deanne is retiring after 30 years. 29 years of service to LRC. And Deanne, I just want you to know how grateful we are for everything that you've done and what an impact her work has had on Kentucky and the health policies that we've been able to implement, institute, draft. Your patience, your kindness, your sense of humor, we are just going to miss you. And your expertise is unmatched. And although I do know that we've got some great folks who are sticking around and we get to work with, hopefully for a long time as well. But I just want to thank you for everything that you've done and give everyone a chance to thank you for your service. And to all the committee members and the staff who are here, we have some cupcakes in the back for you, Deanne, so we can celebrate. And you need to take a look at them, though. They're super cute. So, yeah. All right. I think we need to, do we have any members who would like to introduce any guests? Nope. Well, then you're just all welcome. Thank you for being here. First, we shall approve the minutes of the June 16th meeting. Do I have a motion to approve? Do we have a motion? Do we have a second? All in favor?
Aye.
Say aye.
Aye.
All right. Meeting minutes are approved. We are going out of order since I am not sure that we're going to have a quorum for the entire time. We're going to go ahead and look at the regulations, which are noted on the very back page. We will do the optometry reg and the consideration of the agency amendment reg later, but did everyone have a chance to look at the regulations?
I have.
Okay.
I have.
All right. Senator Douglas, you have a question?
Well, Madam Chairman, there are three regs that I would like to have more time that I had some issues with. I'd like to know more about. If you'd like, I'll be happy to.
Well, we have folks here in the audience. If you could tell us which regulations, we could probably have your questions answered now.
I'm looking at 902 KAR 008 colon 060, the proposed. That would be number 1, 2, 3, 4.
The
down from
salary
top.
adjustment
The salary adjustment.
for local health departments.
Yes, ma'am.
Do we have anyone here from the health departments to discuss those regs? Thank you. If you can make your way to the table, please introduce yourselves for the record, and I will allow Senator Douglas to ask his question.
Good afternoon. I'm Julie Brooks, the Policy Specialist for the Department for Public Health.
I'm Krista Hamilton, and I am the branch manager for local health personnel.
Senator Douglas?
Thank you, Madam Chair. My question is, this particular regulation grants a 5% increase in salary upon successful completion of the employee's initial employment probation period. Very quickly, could you explain to the audience what that probation period is?
Yeah.
Or just the time, just the amount of
It's
time?
a six month.
Okay. What would be the starting salary of that employee?
It depends on the classification. It varies. We have a comp plan, and it's based on grade level.
Okay. My concern is that we've got a particular salary that we're coming in with, which is not really the salary that is likely the expectation 6 months later. So there are other persons who are already working there. I'm just concerned about the escalation in salaries, because it also says it is limited to one increase annually. It talks about those who've demonstrated excellent performance. And my concern is about the escalation of salaries over time. So could you help me with that?
Which section?
Because we're working outside the box.
The probationary period salary increase mirrors what is the state personnel systems increase. As you know, state employees, merit employees come in at a salary, and then if they successfully complete their probationary period, they can receive a 5% pay increase. Employees who are already working in that classification, who maybe aren't at that same level, would be eligible for a parity, so that you don't have someone with less than a year's experience making more money than someone who's been in that same role for 5 years. This mirrors that language in our regulation. I believe it was a 3% increase after probation, and we've just upped it to a 5%. Employees at the local health department who go through an employee evaluation and are ranked in the highest level would then be eligible also for a salary increase, or potentially a lump sum payment based on that performance evaluation as part of the ongoing personnel processes.
May I just one last? I'm sorry, Madam Chair. It also says the wages are only available if they fit within the approved budget of the local health department. Now I have a concern that we're putting more money into administration. So help me with that.
It is the Board of Health?
Board of Health.
Okay, so the local boards of health approve the operating budget for the health department on an annual basis. So it gives that group the autonomy over the budgeting. And if those funds are not available, then they would not be able to move forward with some of the discretionary salary increases and payments that are in this regulation.
Thank you very much. I could keep going, but I won't.
Right. And this is the regulation that we had the agency amendment for. And so my apologies for overlooking that. I had it in my list. I think Senator Nemes, do you have a question about this
Yes, I'd like to
regulation?
have a clarification. The state had a 3% bump, which you do too, and you said you want to mirror it to 5%. Did the state increase theirs to 5%?
It is my understanding that the probationary increase has always been 5%.
No, it used to be
On the-
3%,
in
I'm
this-
pretty sure.
Oh,
I think it's 5 now.
yeah.
Okay, thanks.
Okay. Is there any further discussion, or would you like to go ahead since you're here and explain the agency amendment, what we started with and what we're moving to?
You want to?
Yes, the first part of the regulation is meant for an individual. They can receive up to an 8% lump sum payment. The bottom portion is an across the board lump sum payment that can go for the whole health department. We wanted to strengthen the language by adding the word individual, because every once in a while we get something across our desk that they're trying to do a percentage raise for the whole health department instead of a flat rate. So that's why we wanted to add the word individual up to the top section for, just to try to clean that up a little bit.
Okay. So this is actually limiting the increase.
Yes, so
Okay.
an individual may receive a lump sum payment up to 8% based on their salary versus the across the board where every employee at the health department, they can only get a flat rate, which was $1,000, but we'd already put in for the reg change to raise that to up to $1,500.
Okay. All right. And these are all based on performance and review? Okay. All right. Are there any further questions? Any further discussion? Okay. Well, let's finish this one. Okay. Thanks. All right. Is there a motion to approve this regulation? We have a motion. Do we have a second? Okay. And we will need a roll call vote. If you would do that for us, please, DJ.
Senator Adams. Senator Berg. Senator Carroll. Senator Douglas.
Aye.
Senator Herron. Senator Mills. Senator Nemes.
No.
Senator Rawlings.
No.
Senator Richardson. Senator Tishner. Representative Bratcher. Representative Bray. Representative Burke. Representative Callaway.
Aye.
Representative Camuel. Representative Dotson. Representative Duval. Representative Fleming. Representative Gordon. Representative Holloway. Representative Marzian. Representative Neighbors.
Yes, and I would also like to record my presence, please.
Representative Proctor. Representative Rayburn.
No.
Representative Raymer.
Yes.
Representative Riley.
Yes.
Representative Sharp.
Aye.
Representative Wilner.
Yes.
Co-Chair Meredith.
Aye.
Co-Chair Mosier.
Yes. Okay. The regulation as amended by the agency passes with favorable expression. 17-3. Thank you. Okay. Next, well, so we still have the regulations that are not looking to be amended at this point on the agenda. I think you all are finished at this point, and unless there, let's see, there are other local health department regulations. Did you have another question? Okay.
I did, Madam Chair. This is over the prescription for Schedule II controlled substances authorized for oral prescription for immediate administration, face smile transmission, and/or partial filling.
Okay. And do we have anyone here to discuss this regulation? All right. If you could just introduce yourselves and be available for questions.
I'm Peyton Sands, the deputy.
Can you make sure that your microphone, the green light's on?
Yeah, it should be on. I'm Peyton Sands, the deputy inspector general for the Cabinet for Health and Family Services.
Hi, I'm Susan Harris. I'm the Director of Audits and Investigations in the Office of Inspector General.
Senator Douglas.
Thank you, Madam Chair. Some of the partial filling requirements says pharmacists may partially fill Schedule II prescriptions if the patient or the prescribing practitioner requests it. Now, my concern is, when did the patients get a medical degree? It says patients or.
Sometimes what we find is it's a monetary issue. They don't have the money to pay for the full prescription, so they will ask for a partial fill. So that's how sometimes the patient comes into play with that.
Well, I understand that part, but one of the things that we're fighting right now, we are trying to cut back on some of the abuse of opiates. And I know we're primarily talking about patients who are in hospice or a long-term care facility, but unfortunately, having been in that space for a long, long time, my big concern is with the redistribution of medications if the patients request it. I'd be very, very, very opposed to any patient who has that opportunity to say, I'm hurting more, I need more, and then someone giving him or her those medications without formally discussing that with whomever is in charge of their care and who is also monitoring that intake, given the amount of prescription they're supposed to be taking versus the amount of medication or the amount of substance that they are going through. So that word, the or, really gives me some issues, and I think that's a problem. I think that's problematic.
If I may clarify and maybe ask a question as well, is this, I mean, a partial fill would be less than the indicated or the prescribed amount, not more than, is that correct?
Correct.
Okay, so we're not talking about the patients being able to dictate whether or not they get an additional refill or more than is written as prescribed.
That's correct.
Okay, all right.
Actually, we are, because we're talking about a refill. The word says refill. Now, if we're talking about a continuation of that which has already been written for, that's not a refill. That's a continuation of that which is already written for. A refill, by definition, is something that has to be reauthorized or rewritten for. That is the definition of a refill. So I apologize, but that is, I think that was not an accurate statement.
Right. So if it's reauthorized, then they go to get it refilled, and they don't have the funds to pay for it, or I've picked up
The full
scripts and the
amount.
pharmacy doesn't have it, then they'll issue a partial refill, and then I have to go back and pick up the rest, and that's this scenario.
But it would have to be prescribed. Okay. All right. Does that satisfy your question?
Actually, no, Madam Chair. What I'm really talking about is having the Schedule IIs if the patient or the prescribing physician requests it. Those of us who've been in that space understand that just because a patient asks for something doesn't mean that it is something that they should have. Whether people like it or not in medicine, we really do monitor our patients, and we really do want to know what's going on. I'm okay if it says the patient asks and then the physician is consulted and approves it. But I'm not okay with simply saying because the patient asks, we should approve a refill.
Is that the purpose of this regulation? I'm not reading it that way.
Sorry. No, so it's if they go to the pharmacy and there's been a refill ordered and they go to pick it up, then they can request only a partial because maybe they can't pay for the full prescription at that
Right.
time. And then they'll come back and get the rest when they have the money to do so.
Yes. Okay. All right. Thank you. All right. Yes. Senator Berg.
about medications that have been prescribed. There's a prescription associated with the medication. So there's no way that a patient can use that for abuse by taking less than they have no option to take more.
Right.
So it may be that they can't afford to fill it. It may be that they know themselves and they know they don't need a full prescription. They want to try 3 days, get this under control, and they don't want to waste their money or have drugs at home that they have to get rid of. There's a number of solid reasons not to fill an entire prescription for pain medication. You end up with excess in your cabinet. Believe me, come look at mine. So for a patient to go in and say, give me half of it, there's no harm or foul there. It's been prescribed. It's associated with a specific prescription for that specific, if you don't want to use the word refill, dispensation.
But they're also written for, there are many prescriptions that are written for a particular interval. And my concern is refilling prescriptions early. They still may be refills. And that's why those folks who take a look at their prescription bottle, often there is do not refill before a certain date. My concern, does this supersede that which is written that says do not refill before a particular date? Because understand that some physicians or many physicians operate in different areas of medicine. They deal with this. Other physicians operate in medicine and they don't deal with this. So they don't understand it. They can talk about it, but they don't understand it. And my concern is with the substance use disorder issues that we have in our Commonwealth and in our country, changing to something that may be on that bottle that says may refill X number of, X period. Are we changing that criteria that is put on when those refills can be made with this regulation?
So it would still be within that amount of time that you have for those prescriptions that are for that particular dispense. So it would still be within that window.
My question is still, if a prescription says do not refill before so-and-so, it does not change that bar on that prescription of when it can be refilled.
Thank you.
No, I don't believe so. I mean, you have a partial refill that might be additionally given if they come back to get that, but not a new prescription issued should not be refilled before that date on that
partial
script.
refill, a partial refill, if a partial refill is given before the refill date, it is still a refill. And it is still outside of that which is designated by the provider. My concern is usurping the provider's schedule on which they want to treat that patient. And looking from the outside, inside, unless you've treated that patient, you have no idea what that patient's past history of medication use is. I just want to make sure that you've got a prescription, and there may be 4 other refills, but often it is designated what prescription number, how long prescription number 1 is to last. And it's done that way for a reason. I just want to make sure that this regulation is not usurping that that which the provider is saying, I don't want this refilled before a certain time, because there are reasons.
Senator Douglas, would you like to defer this just to have more time to make sure that the wording of this is clear to you? Because to me, it looks like this is a one prescription. The patient cannot get more medication than is prescribed. They can't get a refill, an additional refill. Outside of, there's if it's a 30-day prescription time, they would have to come back if they got a partial fill initially in order to get the rest of it. Say it's 3 tablets and 3 tablets. They would have to do it within that time period.
Correct.
Yeah,
I would, Madam Chair. I'd like to defer this regulation until we have some.
Do you mind if we just clarify this outside?
Absolutely.
Of this?
That's fine.
Okay. All right.
Thank you, Madam Chair.
Okay. So we need a motion to defer. We have a motion.
Second.
A second. Okay. To defer this reg. All in favor, please say aye.
Aye.
Any opposed? Okay. All right. We'll just talk about it, make sure everyone's comfortable with this. Thank you. I appreciate it. Okay. All right. Okay. Those two. Okay. All right. So thank you for that discussion. And we will move on now to the discussion of the optometry administrative regs. That is 201 KAR 005-021. It's an emergency reg. I would invite the Board of Optometry, Kentucky Board of Optometric Examiners. And we also have Christopher Thacker. Thank you for being here from the Kentucky Attorney General's Office to discuss this regulation. This is something that we have talked about for quite a while, and I appreciate all of the good discussions that we've had, all of the meetings that we've been able to have to get this right. And so before we begin this discussion of the regulation, I believe it's helpful to provide some background so all members of the committee understand how we arrived at this point. The main issue began with questions regarding the administrative process that the Kentucky Board of Optometric Examiners used to establish certain licensure requirements. And this was all during the COVID travel restrictions in 2021. The board started accepting examination alternatives and or waivers for certain parts of the National Board of Examiners in Optometry. And the problem was that these exams were issued without, the National Board of Examiners exams waived parts of these exams without the proper alternatives or regulatory process. After the board promulgated the regulation in July of 2025 to allow an alternative to one part of the National Board of Examiners exams, some questions were raised about the waivers that were allowed by the board prior to the effective date of that promulgated reg. The matter was referred to the Attorney General's office, and so thank you for taking a look at this regulation and reviewing this. I think that the board would agree with me if I said that mistakes were made in the past and we needed to remedy those. And so that's what has happened here. Since the issue of the issuance of the Attorney General's opinion, the issue has been discussed during public board meetings of the Administrative Regs Review Subcommittee, stakeholder working groups, and legislative discussions and public comment periods. Again, I appreciate all of these discussions. I know it's been lengthy and difficult at times. I also want to recognize Representative Derek Lewis, who is chair of the Administrative Regs Committee, and he has also spent a lot of time working on this. We are now, our role now is not to necessarily revisit all of these decisions, nor is it to determine winners or losers among the stakeholders, but it is to review the regulation before us to determine whether or not it complies with Kentucky law, to ensure that it protects the public, and to treat the affected licensees fairly. The General Assembly expects our professional licensure boards to comply with the administrative regs procedure that has been established in statute. At the same time, we recognize that practitioners relied in good faith upon licenses issued by the Commonwealth. As policymakers, our responsibility is to balance compliance with the law, protection of the public, and fairness to those who relied upon the actions taken by their licensing board. I want to recognize the members of the board, Dr. Mary Beth Morris, and who's the president of the board, and the board staff, legal counsel. Thank you for being here, Kristen Webb, and for the work that you've done and undertaken during this process. Whether or not everyone agrees with every policy decision, I believe that the board has demonstrated a genuine commitment to fixing this issue and prior mistakes. That commitment deserves recognition, and I appreciate your willingness to continue working toward a resolution. The purpose of this emergency regulation was to address the licensure issues identified by the Attorney General. I believe the regulation should remain focused on the traditional licensure examination pathway that has historically been recognized for demonstrating minimum competency for entry into practice. After reviewing the regulation, hearing testimony from numerous stakeholders in the past, and working closely with Representative Derek Lewis throughout this process, I will be offering a committee amendment to remove the provision that allows passage of the American Board of Optometry Board certification examination as an alternative pathway to the National Board, Part 3, for anyone taking the exam after this date, starting tomorrow, July 17th, 2026. At this time, I would like to ask Dr. Morris if she is agreeable to the committee amendment.
Yes,
and moving forward, and of course, then I will give you a moment to explain your position and make any comments on anything that I've said or any of these discussions.
Yes, ma'am. Thank you. Thank you, Madam Chair, members of the committee. I appreciate the opportunity to provide an update on the Kentucky Board of Optometric Examiners' response to the AG Opinion 2513 and the work the board has undertaken in the past several months. Since the Attorney General issued Opinion 2513, the board has been focused on two important areas: addressing the KRS 13A and related license issues identified in the opinion, as well as continuing its review of patient safety and expanded therapeutics procedures. As the committee is aware, the Attorney General opinion concluded that the board possessed statutory authority to accept exams other than the NBEO exam. However, the opinion also concluded that KBOE must follow proper KRS 13A regulatory process when implementing any changes to exam requirements to licensure. The Attorney General opinion directed the board to review those licensees who were licensed through waiver of the exam or acceptance of an alternative exam. Consistent with the guidance provided by the AG's office opinion, the board promulgated emergency and ordinary administrative regulations establishing the process for this limited licensure review. These regulations outline the requirements that must be met by the affected licensees prior to licensure renewal. The regulation before this committee has gone through public comment and extensive discussions with members of the General Assembly and others. As a result of these discussions, the KBOE has agreed to the committee amendment offered by Chairwoman Mosier, which hopefully will simplify this process. As originally filed, the emergency regulation required the individuals who were licensed with alternative exams or waivers not promulgated through KRS 13A to demonstrate successful completion of NBEO Part 1 or the OEBC, NBEO Part 2 and TMOD, and either NBEO Part 3 or the American Board of Optometry Board Certification exam before license renewal. The emergency reg also restricted these licensees from performing laser procedures until all requirements of the regulation are fulfilled. After public comments were received and properly considered, the KBOE amended the emergency reg to remove the OEBC as an alternative to NBEO Part 1 for any licensee taking the exam after April 15th, 2026. If the committee adopts Chairwoman Mosier's amendment, the regulation would also remove the ABO Board Certification exam as an alternative to NBEO Part 3 for any licensee taking the exam after July 17th. As a result, all licensees who received licensure under an alternative exam or not promulgated in a regulation will be required to demonstrate successful completion of NBEO Part 1, Part 2, TMOD, and Part 3, prior to licensure renewal. The Board appreciates the collaborative discussions that have occurred throughout the legislative review process, and legislative input is truly valuable to us. We plan to continue to update you on any future concerns that you might have and update you about the continuing progress to improve operations and correct prior mistakes. While addressing these licensing matters, the Board has also undertaken a comprehensive review of its internal policies and procedures. So our goal is not only to address the procedural matters identified in the Attorney General's opinion, but to also strengthen the Board's administrative regulatory processes so that future licensing decisions are implemented in accordance with Kentucky law and established administrative procedures. In this vein, the KBOE has done the following things since issuance of the Attorney General's opinion: retained outside legal counsel, removed additional test options for initial licensure so that all pre-COVID requirements are in place, proposed administrative regulations and amended such administrative regulations based on public and legislative comments. We're in the process of updating policies and procedures. We have required conflict of interest disclosures. We require full Board approval of all initial licensure applications. We participated in legislative hearings and meetings with legislators, waived licensees from performing laser procedures until all requirements are fulfilled. We've revised and updated our website to immediately post Board-approved minutes and a licensee lookup feature. These changes on the website are ongoing. We also created the Expanded Therapeutic Procedures Work Group with optometrists and ophthalmologists, educators, and national experts. The Board is committed to continuous improvement and consideration of public and legislative input, transparency, compliance, and protection of the public, while providing clear, consistent standards for Kentucky licensees. Additionally, the KBOE continues to focus on patient safety and the responsible oversight of Kentucky's Expanded Therapeutic Authority for Optometrists. To support that effort, the Board established the Patient Safety and Expanded Therapeutic Procedures Work Group to conduct a comprehensive review of Kentucky's expanded therapeutic credentialing process and determine whether changes to education, procedural competency, credentialing, patient safety standards, or regulatory requirements should be recommended. There are now 17 states with expanded therapeutic procedures, and Kentucky has been successfully providing these services and performing these procedures for over 15 years. The work group was composed of subject matter experts with decades of combined experience, including members of the KBOE, Kentucky laser credentialed practicing optometrists, practicing Kentucky ophthalmologists, including anterior segment and retinal specialists, a faculty member from the Kentucky College of Optometry, a nationally recognized optometrist with extensive experience in laser education, credentialing, and advanced procedures. The work group met on several occasions to evaluate clinical education and procedural competency, candidate and proctor credentialing requirements, patient safety protocols, documentation, oversight measures, and opportunities to strengthen Kentucky's regulatory framework. Following this comprehensive review, the work group formally approved 15 recommendations intended to preserve Kentucky's existing education-based pathway while strengthening procedural competency standards, proctor qualifications, and oversight. These recommendations will be presented to the Kentucky Board of Optometric Examiners for review and consideration as the Board evaluates potential updates. I am incredibly proud of the thoughtful, respectful, and robust discussions that shaped these recommendations, and I'm deeply grateful to each of the members of the work group for their expertise, time, and care that they brought to this important work. So, Madam Chair and committee members, thank you so much for your oversight and your continued engagement. We truly value your insight and feedback. We also appreciate the collaborative approach taken by the General Assembly throughout this process, particularly the leadership of Chairwoman Mosier and Representative Derek Lewis in working with the Board to identify a constructive path forward. The Board remains committed to transparency, accountability, continuous improvement, and faithful implementation of Kentucky law. Patient safety and public confidence is top concern and priority. We will continue working collaboratively with the General Assembly and the Attorney General's office, healthcare professionals, and other stakeholders to ensure Kentucky's regulatory framework protects the public while maintaining confidence in Kentucky's licensure process. Thank you for the opportunity to provide this update, and I'll be happy to answer any questions.
Thank you, Dr. Morris. I appreciate your excellent explanation and all of the work that you've done. And I should also mention that many of my colleagues have been involved in this conversation, but Senator Meredith has been right with us the whole way as
Great.
well. I appreciate just making sure that we are providing consistency in licensure and measuring competency, and it's all about patient care. We do have a couple of quick questions, and don't forget, members, we have 3 presentations. So, Senator Adams.
Thank you, Madam Chair. Just so that the committee knows, and I've asked you this before, how many individuals are we talking about that have an active Kentucky license but have not passed all 3 parts?
It's a great question. So I'll be happy to give some approximate numbers. So whenever we started, the board identified about 34 licensees when the investigation began. Before the beginning of 2026, 9 of these people had already completed NBEO or moved out of state and deactivated their license. So about 25 people were required to complete these steps in the regulation. As of yesterday, there were still 11 people that are currently outstanding. But you have to realize these numbers are in flux. So some people have already taken some of these exams, and the exams take about 2 months to receive the results. So, but to answer your question, that is approximate numbers.
Thank you.
Thank you.
Okay. And I should offer Mr. Thacker an opportunity to weigh in if you have anything here that you'd like to mention.
I don't really, Madam Chairwoman. Again, happy to answer any questions if there are any. But,
I just wanted to make sure that you had an opportunity. And I'm not even sure that I had everyone officially introduce yourself for the record. So you might need to do that as well. Just state your name just so that we have that.
Christopher Thacker, General Counsel, Office of Attorney General.
Thank you.
Mary Beth Morris. I'm the president of the Kentucky Board of Optometric Examiners.
Kristen Webb, I'm the General Counsel for the Kentucky Board of Optometric Examiners.
Okay, I'm just making sure that our staff has everything they need. Representative Wilner.
Thank you, Madam Chair, and thank you for the work you've done and for the very thorough explanation. I actually had the same question as Senator Adams, but got a couple of other just really quick. I'm curious. So this, as we talked prior to this meeting, and my understanding is this puts everything back to where it was pre-COVID, correct?
Yes, ma'am.
So that's good to know. And I love the part about having the licensee lookup feature on your website. That's so important for public protection. I wonder if there'll be any designation of optometrists who may have received their license through an alternative path so that patients, potential patients, are able to have that information.
I don't know that that's on there at now, but that's something that the board could consider.
Thank you. I hope you will.
Thank you.
And the last really quick one is, did I understand you correctly to say that even those 30 or 11 or whatever number it is currently, when they go to renew their license, in order to have their licenses renewed, they will have to complete the full exam series?
In order to renew their license, so optometry licenses are renewed annually. So in order to renew their license, they will have to have shown that they have completed everything that's laid out in the regulation, all the exams that are in there.
So just to clarify, so they renew, they got licensed through an alternative path. Will they be able to stick with that alternative path through the end of their career, or will they have to at some point make up the exam that they missed during this brief period?
So the alternative paths that were approved through a regulation previously, those people can still renew with those alternative paths. So this regulation will affect going forward tomorrow. Anyone who takes the exam has to take the NBEO Part 1, 2, 3, and the TMOD.
Thank you very much. Thank you.
Thank you. Representative Duvall.
I'd like to say thank you to the KBOE for the wonderful presentation today and explanation. Thank you for your willingness to meet with multiple legislators and get a wide variety of input that has helped guide these decisions that you've outlined today. Thank you for your priority on patient safety and high standards as well. But my question is really for the Attorney General's office. And so I just want to make sure that I understand this clearly, that that the original Attorney General's opinion from back, I believe it was in October, it was really addressing how the prior examinations were implemented, and that did not say anything about the board's lack of authority to approve those, and also did not say anything about the licenses needing to be revoked. I just wanted to make sure I was clear on that.
Yeah, so in fact, the bulk of the opinion is answering the first question, which was, does the board have the authority to approve some alternative testing? And the answer, the statute is very clear. As it stands, they can approve any testing organization that they deem is appropriate. So the issue was never the substance of what they did. It was all about 13A process. They have a regulation that comports, or had a regulation that comports with the statute, and they attempted to modify basically those regulatory requirements by a simple board vote without going through the 13A process. That's what we said they couldn't do, and we said that action was improper, and as a result, you now will have presumably licensees who were licensed without complying with the regulation, and you need to review that and remedy that. We never said, and would not be appropriate on the facts we had at the time or today, to say that you can or should simply suspend those licenses. I think I've said in an earlier legislative hearing that you can't cure that 13A problem by curing a 13B problem, by which I mean that once you give them that license, even if you did it unlawfully, you've now there's got to be some degree of due process in how you remedy that with respect to the interest and potential expectation and potential rights of the licensee, who again was, complying with what they were being told by the board at the time. So you're absolutely correct, Representative. We did not say exactly what the remedy had to look like. We just said that you've got to bring your practice in compliance with regs, and ultimately by amending the regs, that we believe that the board has done that.
Thank you. Thank you, Madam Chair.
Okay, thank you. All right. I would like to entertain a motion now to approve the committee amendment. We have a motion and a second. And DJ, please take the roll.
Senator Adams, Senator Berg, Senator Carroll, Senator Douglas, Senator Herron, Senator Mills, Senator Nemes,
Aye.
Senator Rawlings,
Aye.
Senator Richardson, Senator Tishner, Representative Bratcher, Representative Bray, Representative Burke, Representative Callaway,
Aye.
Representative Camuel, Representative Dotson, Representative Duvall,
Aye.
Representative Fleming, Representative Gordon, Representative Holloway, Representative Marzian, Representative Neighbors,
Yes.
Representative Proctor, Representative Rayburn,
Yes.
Representative Raymer,
Yes.
Representative Riley,
Yes.
Representative Sharp,
Aye.
Representative Wilner,
Yes.
Co-Chair Meredith,
Aye.
Co-Chair Mosier.
Yes. Okay, so the motion to approve the committee amendment has passed with favorable expression. Again, thank you so much for all of your work. We look forward to working together in the future. Thank you. All right. Thank you all so much for your patience in getting through those very important regulations. Next, I would like to invite Auditor Allison Ball and the Executive Director of the Office of Ombudsman, Jonathan Great, to the table. And Alex Magera, welcome. Please introduce yourselves for the record. And we would love to hear an update from this newly formed office and hear about what you're doing to help us investigate and prevent fraud and all the other things that you do. So thank you and welcome.
Thank you, Madam Chair. My name is Allison Ball. I'm the Kentucky State Auditor. The two individuals to my right and to my left, I have the Ombudsman, John Great, and I have General Counsel Alex Magera. Thank you so much for the opportunity to discuss this. This is relatively recent still in the Commonwealth of Kentucky, and we have issued a report of the work that's happened since it was transferred from the Cabinet for Health and Family Services to the Auditor's Office. And I believe everybody has a copy of that. It's publicly available. It's on our website, and it came out a few months ago. But I really appreciate the opportunity to dig in a little bit because, as we know, the work that we do can get a little dry and a little technical, and sometimes it needs a human voice to walk it through and explain it in a way that just makes it come alive a little bit more and it's just a little more relevant. So by way of background, because one of the things I was asked to do was to explain, this is the first time that we've done a report since the Ombudsman's office was moved over from the Cabinet over to the Auditor's office. And just a little bit of background is helpful to know, and I know most people in this room will remember it, but how this happened. Back on June 3rd, 2022, the General Assembly established the Cabinet for Health and Family Services Organizational Structure, Operations, Administration Task Force. So that's how this got started. There's a review of was it appropriate for the Ombudsman's office to stay at the Cabinet for Health and Family Services, or would it make more sense for it to be moved? So that way there's true accountability. And the General Assembly determined that it made a recommendation in November of that year that it would be much better to move it to under the control of the Auditor's office. There's actually been two bills that have done that. There was a Part 1 and there was a Part 2. 2023 Senate Bill 48 was the first part. That was Part 1, and that moved it from the Cabinet, from Health and Family Services, under the umbrella of the Auditor's Office. And then in 2025, Senate Bill 25 just clarified, it was essentially a cleanup bill, and once it was moved, okay, now what is the best way to make it move going forward? So that's the legislative background for how it happened. I think it's interesting to note, before the move happened, the most significant investigation that the Ombudsman's office had conducted was a determination whether or not a form was too complicated. So back in that point in time, you had investigations where the public would call in and raise concerns, and there would be reviews and things that would happen from that. But the only actual investigation that resulted in something that was noteworthy was something pretty simple. And I think if you look at the report and the work that's been done in the last the report covers a little over a year. It's been 2 years since it was moved over. If you look at the work, I think you can see that this was an excellent decision on the General Assembly's part. There is, I think, now true accountability. It really is functioning the way I think it was originally intended to. It's not just a part of the bureaucracy anymore. So I'll run through real quick several of the notable items from the report, and we can dig in as we need to. I know there's a lot, so I'm going to try and be fast about it. The Cabinet for Health and Family Services, as you know, has a $24 billion budget, so there's a lot of money that goes through this cabinet, and it reaches essentially every Kentuckian in some way. And I think it's important to remember it's not just vulnerable Kentuckians, foster children. We think of that, people that are elderly, people on Medicaid, Medicare. Obviously, it touches all of them. But because of the vast reach when it comes to Kentucky's health, it really does touch so many people. So it's critically important that the Ombudsman's office does its job and functions in a way that is making sure the Cabinet is truly accountable. One of the questions I was asked to address today was, how's it going? What's your relationship with the Cabinet for Health and Family Services like? How how are the interactions? And I've already testified about this before, but part of the answer to that goes back to when the Ombuds office was first moved over. We got off to a kind of a rocky start on one particular issue. We had some good transitions, some good meetings. A lot of things came over really smoothly. The entire staff, except for core leadership, came over from the Cabinet for Health and Family Services, and the bulk of that staff is still the exact same that came over. But there's one particular issue that was a difficult one for us to get over to begin with, and it was a tremendous issue because it was essential, and that was access to the database called iTwist. And many of you will remember what that is. It is the Child and Adult Abuse and Neglect database. And it's always been a primary source for investigators in the Ombuds office to be able to review complaints regarding foster care, the elderly, and you cannot do the job without access to it. And it was universally accepted by everybody, the Cabinet, everyone who discussed it, that the Ombudsman had to have access to it. But we really reached an impasse for a while where we just could not get an agreement to allow access. So everything for about 4 months was moving slowly because of that. And in fact, we actually had to initiate a lawsuit just to be able to get access to it. Happily, that lawsuit resulted in a settlement which gave us full access to it, and we were able to proceed the way we were supposed to. So we started off with a difficult issue, and there's been sort of a mix ever since that point in time with some good communications, which I'm happy to talk about because those matter, but also some other areas of impasses, and I'd like to see those not happen. I'm someone who loves to work collaboratively when possible. So my hands are always open. I really do want to solve things. I want to be results oriented and not really care who gets the credit. So I say that at the front end because I know sometimes there's people listening from the Cabinet. We really do want to work, and we believe in results and not standing on principles and having to get your way. So with that, several issues have just sort of arisen, and we've never had great clarity on a couple of things. One is complaints made to the Cabinet over to us. We haven't had total confidence that we receive all the complaints. And so that's a work in progress at all times to make sure if a complaint comes to the Cabinet, that it also makes its way over to the Ombudsman. We've done a lot of work on our end to make sure the Ombuds office is the complaint source, but it doesn't always happen that way. And that's a continuing work in progress. Also, just obtaining all the Cabinet's policies and procedures so that way we can have a benchmark to make sure that, in fact, they are following policies and procedures. Those are just ongoing issues that we've had several times. One notable issue that we've had, and you'll be well familiar with this, is the kinship care issue, and that is still an ongoing issue. It's one I'd hope to have resolved. The General Assembly passed a bill to make it easier for kinship care families to get resources, and there was a dispute over the cost of the particular program, and we've been involved from the beginning from all aspects of our office to try and get some clarity on that, and we haven't been able to reach a resolution, and I'm sorry for that. It's one we've continued to work on, and we do continue to work on it. We do still have an ongoing legal issue on it too. It's currently in front of the Court of Appeals, and it's set for oral arguments on October 23rd. So rest assured, we're still working on it, and I'm personally disappointed that we haven't had a resolution to that, but we do continue to work on it. Something else that's worth noting, just talking about the relationship between the two, when we first began announcing things that we were working on from the Ombudsman side and some issues that involved the auditor's office, that was October of 24. October 23rd, we announced the beginning of the kinship care issue. And then we also announced that we were going to be reviewing the issue that had come to light about foster kids sleeping in office buildings. That was October 29th. Almost immediately, on October 31st, we got a request, an open records request from the Finance Cabinet asking us to unmask our whistleblowers in that issue. Now, it's the first time in the history of anyone's memory in the auditor's office that we had ever been asked to reveal a whistleblower. Obviously, we work quite a bit on tips. Many times it comes from within organizations, so we're very, very serious about protecting confidentiality. We said no, you can't have access to this. We cannot do our job unless we can have people's confidences that what they say to us is protected. So we stood our ground on that one, and the Beshear administration actually appealed it, and the Attorney General's office determined that those were whistleblowers and they were entitled to protections. And in fact, when the cleanup bill came forward in 2025, the General Assembly codified that and clarified that people should have the confidence to be able to provide information knowing that that information will not be revealed, because that would subject them to retaliation and all kinds of problems. Looking at the report itself, and we discuss many of these things in the report too, because sometimes the background is helpful to know. We then began to discuss some of the more granular details in it. We talk about the 20,617 complaints that we received in 2025. Again, there's still some question about whether or not we received all of them, because we had some indications that not all of them were transferred over. But for the ones we got, we were diligent about reviewing those instances and making sure people had the help that they needed. We also issued, as a result of some of those, 150 correction action plans. And those are significant because that's how you get things corrected. There's requirements on their part that they update us, and we make sure that issues are, in fact, truly being addressed. The kinship care issue continues. An issue that we I think had good collaboration on is an issue involving credit checks for foster youth. It came to our attention that it's not uncommon for foster kids' identities to be stolen. And it's a real area of vulnerability for kids that are already at risk for so many things. They don't also need their Social Securities taken, and lifetime of problems that happen as a result of that. So we were able to work with the Cabinet for Health and Family Services to update outdated policies that did not address that. And I'm happy to say that is something that is now much stronger. So that is a win, and it's a good example of good collaboration, and I'd love to have more of that. Another issue that we dealt with was the HCB waivers. You may recall that in May of 2025, there was a whole slew of people who were denied their HCB waivers. They had been on it, and then they were told that you are no longer eligible. And it came as a surprise to a lot of people. There were a number of parents who contacted us and said nothing had changed in their child's life, but they were notified that they were no longer eligible for it. And so it was a tremendous upheaval for a number of families. And so we got involved in that, and we engaged the Cabinet for Health and Family Services, and there have been some steps to make sure that that's remedied. It was a third party, a subcontractor, who had created the problem initially, and there have been several areas that have been taken up to address that, to make sure people were put back on again and that this doesn't happen. So it's another example of some collaboration. That one actually took a little more effort than the foster care issue, but we did get somewhere on that one. The child waiver rollout situation, as you may remember, the General Assembly passed HB 6, which appropriated $14.7 million to create a new home and community-based waiver for children ages 0 to 21 with severe emotional disabilities, autism, or intellectual and developmental disabilities. It was, I think, envisioned to be a way to help some of this long wait list that's just developed over the years for a lot of children, and then some emerging adults who have just waited a very, very long time to get the help that they need. We had some concerns because the Cabinet stepped in and added some restrictions to it that did not seem to be in line with what the General Assembly intended. So we got involved in that. We issued a comment letter. We continue to be involved with it. I mention this because it's covered in the report, but it also has some current relevance. Because you may have noticed in the news recently, there was an issue about parents with children with severe autism who were having to find institutions that could help their children. Many of these kids had gotten older and they were physically stronger, and they were having to go out of state to find places that could take care of their kids. A lot of really sad stories from parents who were doing the best they can to try and resolve these issues. The Cabinet came back. There was an open meeting for these families to raise their concerns, and the Cabinet came back and referred to this particular waiver as a solution to that. But we have begun to weigh in on it because with the restrictions that they added to it, it is not a solution. It can't be used out of state, and there's a variety of problems that would really just exclude people from being able to use it. For one, it's only permissible for 100 people, so it's a very, very small collection, and that was not in the original bill. It was an added component to it. So this was something that rose several months ago, and it's just arisen again in the last month or so because of this particular issue. We also have done some reviews of some particular cases. We've just becoming more robust in our review process involving foster children and other at-risk children. We've been doing a more intentional review process of child fatality cases. We've had 6 particular cases that we reviewed that have resulted in a revelation that I think is important. We found that it's not uncommon for documentation to be entered weeks or months after a child dies. So there's no clarity that this was done in a way that you know that it's accurate, because it didn't happen prior to it. It's not documented in the immediate aftermath. A lot of time passes. And so that's something that we have noted as an issue. Also, just wide discretion around the Commonwealth of Kentucky about what to do in these kinds of cases, what kind of seriousness leads to involvement, and then sometimes a child dies, and you can see just variation in what steps led to the particular tragic incident. So we just saw a lot of inconsistency throughout the Commonwealth of Kentucky. So we have our review process now. It is still mostly cursory, and I think because what we have found has been alarming, it warrants a deeper investigation, a deeper review of it. We've also reestablished a review program that had previously been discontinued. It happened prior to our involvement, and we're reviving it, and I think we're making it stronger, which is to do an independent structured case review across DCBS cases. So it's going to be all around the Commonwealth of Kentucky, and I think that's going to really help with consistency and catching problems at the front end throughout the Commonwealth of Kentucky. We also, this is an example of collaboration. We were involved in reforming the adoption matching systems. Previously, the efforts to find foster families to lead to adoption was a little bit like Little Orphan Annie. It would be posting pictures of kids and describing things about them on Facebook and other areas, trying to solicit families to come in and adopt. And there are risks involved with that because it's not a data analytics review. You're not finding out, is this really a good match for your family? It's almost like advertising. And that raises all kinds of problems for the children themselves. These kids go to school. They're around other children who can see their pictures show up on social media and other outlets. It's embarrassing. It subjects them to bullying. It's really not good for the kids, but it also is not effective in finding good parents to take care of these kids. And other states have actually reformed that, and they're starting to use data analytics instead of just an advertising solicitation process. Florida is using data analytics. We made a recommendation about improvement in this in our report, and the cabinet is taking that up and fairly recently announced that they're going to begin using data analytics. I'm really hopeful that's going to improve outcomes. We see a lot of placements for kids, and that's because I think the placements aren't well tailored to the kids. And hopefully this would prevent, and you can't entirely prevent it, but this will prevent a lot of placements from going to families that just aren't ready. They're not the right appropriate family to take care of these particular kids. So I'm really hopeful about what comes up out of that. Another issue is the medically complex foster parent shortage. We've dug into that a little bit to try and figure out what are ways to increase the amount of families that are willing to take medically complex children, foster homes that can do that. There aren't a lot right now. There's 119, I believe, by last review that we did on September 9th, 2025. There are 218 medically complex kids, so there are fewer foster homes than there are children, considerably fewer homes. And one of the things, this is interesting, when you actually do a review of this, you start to find out areas to reform that are easy fixes. This is one of those. We found one of the challenges is that foster parents are required to do 2 days of training a year, and that training is usually in Lexington or a place like that. So you've got parents that are from McCracken County, and they can't find someone who can take care of their foster child with cerebral palsy to be able to take a day off to come to Lexington and do that twice a year. So this is low-hanging fruit. It is an easy fix, and we made recommendations to be able to increase training, maybe some online opportunities, but it really would not be difficult to have some regional hubs to be able to help with this. There are other states that have taken steps to address this issue, and we can as well. So I'm really hopeful about this. Is one of those things that when you actually just do a dive into, you find out why parents aren't willing to do it. It's something as simple as not being able to take off work, drive, and then find someone who can care for your medically complex child. Another issue that that's one that kind of arose by people calling us, was a data breach issue that happened in August of 2025. We had a adopted mom. She had been a foster mom. She adopted several kids, and she was very alarmed because the birth mother had gotten access through the mail to her children's new names, and I think it also included their new address where they were living at. So this really concerned the adopted mom. It allowed us to know that there could be a problem here. It may not be just a one-off, and we found out through the course of correspondence with the Cabinet for Health and Family Services that there were 2,465 children who were affected, individuals, not just children, who were affected by this data breach. And steps have now been taken to address that. We did have some concerns because when we engaged the Cabinet, they minimized it and said that they only had 3 examples. But the Cabinet also, in correspondence with us, it wasn't the formal letter that we received, but in other correspondences, they confirmed to us that it was about 2,500 individuals. So we remain vigilant to make sure anybody who had this happen to, that they know it, so that way they can take whatever steps they need to. And then we're keeping an eye to make sure the Cabinet never allows this data breach to happen again. A single instance, but it ended up, I think, having a wide-ranging impact, was we discovered a facility that we refer to as Little Creek Behavioral Health in Arkansas. It was one of those out-of-state institutions that has come forward as being able to help people with children with severe autism and other issues. And it's one that the Cabinet had placed a foster child with. And we had, I believe it was just through some newspaper reporting, saw some coverage about this particular institution and found that they were behaving in ways that were not compliant with Kentucky law. For example, they were using chemical restraints on youth. They were also secluding youth in ways that were completely inappropriate. We brought this to the Cabinet's attention, and the Cabinet responded appropriately. They pulled the child out and made sure this facility is no longer included in an okay list for children to be sent to. So I think this is another example of just being vigilant, watching what's happening, making sure we're catching every area we can. I'm not going to spend a lot of time on this because we did an entire report on this, but we did do a lot of work on the foster children sleeping in office buildings, in hotels and some state park facilities and other locations. The only thing I wanted to give you today, which I think is helpful, is an update. So during our report, we had documented over 304 children from January 1, 2023 to October 29, 2024. And we have done a review because we'd like to see this to end, and we want to see improvement in this area. So we just did a cursory review, not a super in-depth review, but we did a cursory review to determine if there's been any improvement. And our review of January 1, 2026 to June 30, 2026, so nearly half a year, 81 children were placed in non-traditional placements, which is completely on track with the period of time that we reviewed. So we have not seen a marked improvement yet on that particular problem. We also have some concerns that CHFS is not documenting thoroughly these issues. So we hope we are catching all of them, but we don't have confidence that we are catching all of them. We've also received a couple of reports from out in the field from individuals who's told us, we've had a guardian ad litem who've told us that in their experience, the Cabinet officers, the Cabinet staff in their area, the social workers, have been trying not to remove children from homes even when the homes are dangerous because they don't want to increase the numbers of children in office buildings. That's anecdotal. We've heard it about one particular region, but it does give us some concern, and so we're weighing in on that. And then another is we've had some reports of social workers who are not trained to stay overnight, or their administrative workers or their security guards who have been required to remain overnight with foster kids. And that's one of the things that we have been concerned about for a while, is that you don't have appropriate training and personnel for kids staying in these particular locations. Okay, that's a lot. What I'm about to get into is a little bit technical. I'm sorry, you probably are hoping I was done. I'm going to review really quickly the error rates involving Medicaid, etc. I'm going to try to do it fast. This is one of the areas that is most purely auditing like from the Ombudsman's office. So one of the things that we have reviewed is the able-bodied adults without dependents change in the law from the one Big Beautiful Bill. Previously, 117 out of 120 counties had waivers in this area. So they didn't have to be complying with this requirement. They had waivers. That has gone away, and now there's only 5 counties that are receiving waivers from having to follow this. That's just a change because of change in federal law. But we are watching it because we have some concerns that the local people who are dealing with this are not perfectly trained for this yet. So we strongly feel like there needs to be some increased efforts to make sure that they are fully trained for it, because people who are currently not doing the work requirements, they only have a 3-month period to be compliant. And so we have some concerns that the error rates are going to jump up quickly, because you've got people who probably aren't very well informed who are receiving benefits currently, and then you've got staff who we have some concerns aren't very well trained to know what to do to make sure it's communicated properly and that it's addressed. So this is an issue that we see is looming on the horizon, and we're afraid it's going to raise our error rates because of what we see coming. We also do a lot of work just calculating error rates in a variety of things. We do the most work when it comes to SNAP benefits. We do a lot of work with SNAP. We actually go out to offices and do reviews. We do a variety of different types of errors. We can get super into the weeds on this. I will spare you because it is very, very dry, but if you really wanted to get into it, we could. One of the things we do is we do the complete error rates. So for fiscal year 25, there was an 89.25% complete error rate, every kind of error, even minor errors, ones that don't really amount to very much. Our year to date right now is 84.60, so it's a little bit better. We pay attention to that because it's sometimes a preview of problems that need to be corrected. So we're checking a lot of things at the front end so we can signal, hey, there's issues coming, fix it now before it becomes a real serious issue. Those numbers are big. It means about 8 out of 10 SNAP cases that we review have at least one procedural deficiency. Most of the time it's not a serious issue, but we think it's important to check things in the front end so you don't end up with a serious issue on the back end. The reason why I really want to pay attention to this, though, is there is a federal component that we have to pay attention to, and you cannot, for the per rates, you cannot be more than 6%. Last year, we were 3.52%, which was good. It had us way under. We have some concerns currently because we are looking at 6.60 for our year to date. So we are weighing in now. There's still time to get this corrected. We have about 2.5 months to get this corrected, but this is important, and this is one of the reasons why we're engaged, is because we check it every month. We're working on it every month to make sure we catch it before it ends up being an issue. This is one of the only instances, though, where we actually could be on the hook for some more money if we don't catch it right. So it's one of the reasons why we are very vigilant. We're super engaged. We were calculating how much money is potentially at risk. If we were to lose federal funding, it could put us at having to increase $65 million. So it's not pocket change, it's real money. And so we are paying attention to that. As I said, this isn't a problem yet, but it's a looming problem, and we're trying to make sure that this gets addressed. One of the changes, we've had really good collaboration with the Cabinet for Health and Family Services on this, and the Medicaid folks and everybody. We've had really good collaboration. However, we have noticed just recently a change in their process about no longer having our monthly meetings with the field workers. We are continuing to have upper management, and that's good. It's really good. But we've always thought that it was important to also have monthly meetings with the field workers, because they're the ones who are boots on the ground doing all of this. And it is a change, and it's occurred for decades. So this is a very, very recent change. They've told us they feel like they're overworked. And I'm sympathetic to those situations, but error rates matter here, and we feel like we can catch things on the front end. So it's our strong recommendation to keep us very much involved so we can catch things on the front end. Just a little side note on that, when it comes to SNAP, this is not part of the 6%. This is just something we calculate. We calculate how much money goes to people who are determined to be ineligible. And we have calculated, if you look at the ineligible people, it's $73 million. I'm only mentioning that because we pay attention to losing federal money, but we also looked at waste. And this is just an example of we look above and beyond when it comes to error rates. So we also are not just wasting money. We don't want penalties, obviously, but we also don't want waste. So we're paying close attention to that. Some other types of error rates that we review, we look to see people who have been denied or discontinued benefits when they shouldn't be. That's something that we pay close attention to as well. And right now, last year it was 39.66%. This year it's 26.37% year to date. It's better than last year. So we're very engaged in that. That's an overview of SNAP. We have more requirements from the federal level when it comes to SNAP than anything else. So we do more work on SNAP than we do on anything else. We aren't necessarily required to be very engaged in these other error rates, but we do it to help. When it comes to Medicaid long-term care programs, we're not necessarily required. The Commonwealth of Kentucky is required to be engaged in this, but this isn't necessarily something that we have to do. But we do it because we're always reviewing rates and we've developed an expertise in it. We have calculated 43.10% year-to-date error rates within that program. Last year it was a 47% error rate, so we're pretty much on hand on that. Just to kind of give you an idea of the money you're looking at, it's between 148 million to 173 million. I know that's a big gap, and there's reasons for why to explain the cost of it that gives it a wide range. But I mentioned that just to let you know it's real money. And another area that we do reviews on that we jump in to help is Medicare Savings Program. That one also has a very high rate. It has a 30.30 error rate. Last year was 28.50. If you look turning this year's numbers into real numbers right now without changes, you're looking $19 to $23 million in waste. Magi Medicaid is also another one that we're just engaged to help. Sometimes the federal government will rely on our numbers when they need some additional assistance, so we're very engaged on that one. The error rates are much lower in that area. It's 4.29. Last year was 5.33, but because of the high number of Kentuckians who are on there, there's 1.4 million Kentuckians who are on there, you are still looking at real money. A small percentage is a big amount of money, and it amounts to between $200 and $307 million of waste. I know it's a big gap, and we could explain why the gap is so big, but just big picture, that's what that is. We review TANF, KTAP, and KWP. That's required, and the cabinet contracts with us to do that. The year-to-date error rate, in particular for the Kentucky Works program, is 11.48, which is a little bit more than last year, 9.78. And then the Child Care Assistance Program, we're required to do that one. Error rates are low on that one. It's 1.84 error rate. That's a year-to-date. Last year it was 1.5. So we are very, very engaged in error rates. I think it matters to do that granular. We do the ones, of course, that are required of us, and then we do a little bit more. And that's a great example of collaboration with the Cabinet for Health and Family Services and the Medicaid folks and everybody who deals with this. And we want to continue doing that, and we think when we're involved, we fix things on the front end. So I know I just gave you a lot of information, but that is a good summary.
Thank you so much. Wow. You were the right person to have. I mean, I am thrilled that the office has been moved to the auditor's office, first of all. Congratulations on great work. What a great service this is for our constituents and all citizens in Kentucky to know that they have someone that they can call if there's an issue. And it sounds like we can better partner as legislators with your office if we have some concern that we really want to have looked into. So thank you for that. I love your insights and your recommendations. I look forward to working with you and looking at any recommendations that we can help you with to improve the services that we offer our citizens. So I know we have a couple of questions, Senator Berg, and we're going to have to tighten things up a little bit. We still have 2 presentations. Thank you.
Thank you. Thank you for your presentation. I did honestly have a little bit of problems separating the SNAP findings from the Medicare and Medicaid, which is really what I'm here to listen to this afternoon. For Medicare and Medicaid, you said 148 to 173 million dollars in what?
Okay, so we have a lot more detail on SNAP, which is one reason I'm super heavy
Right,
on that
but
one.
I
So
really specifically am asking about the health care.
The specific 148 to 173 million dollar one, which is the 43.10% error rate, that one is Medicaid long-term care specific. So
And
that's
when you're
for,
talking, excuse me, your error rate, are you talking about the error rate that Medicaid puts out, like at our 3.52, or are you talking about your error rate when the forms are not completely filled out?
This one is specifically eligibility.
And the mistakes are 148 to 173 million dollars. Do we have some examples that you could share with us so that we can understand what we're talking about here? Because I know in last meeting you said we could save, 170 something million, but you were actually referring to the old thing where people were double enrolled during COVID in multiple states. And when you were paying capitated payments, this state was paying and that state was paying. There was nothing Kentucky could have done to fix that or recognize that. That was revealed on a national level by the Biden administration. And the data is wonderful and I'm glad it's fixed, but we need data going forward. I need to know, how are we funding Medicaid in this state? And what have you found to help us answer that question?
Yes, very good question.
Thank you.
So the 148 to 173 million, that's specifically about eligibility for the long-term care. And that has to do with looking at their resources, a variety of other things that make them eligible to receive the long-term care, going to a nursing home or something like that. So we have recommendations as we go through. We can see sometimes where the errors occur and where they could be improved upon. And that's usually in our back and forth. We're not just figuring out the errors and just giving a number. I agree with you. One of the things we need to do is make sure we're correcting it. It's not just identifying there's a problem, it's in the past, what do we do? 100% agree. And that's one of the things that we do is we actually do get granular with the folks that we're communicating with to be like, okay, we can see it's X, Y, Z. These are the kinds of patterns that result in eligibility problems, et cetera. But this particular number, one of the reasons why this one's helpful is because it's eligibility. It's not just broader.
I'm sorry, can you give us just a few examples of actual mistakes that you actually found that actually have a significant impact?
Yeah, in the aggregate, they have significant impacts. So it would be like resource calculation, et cetera. They get very technical, and I can get you some actual stories where we come into.
Okay,
if
and
you'd
I don't
like.
want to take up too much time. Is there a way to simplify the application processes to diminish the more computational type of errors, so that? It seems to me if the children can do it with a 1.2% error rate, and we're talking about 84.6, something's more complicated about what we're asking them to fill out. Can we fix that?
That is correct. It's not just a form error, though. Sometimes it is like truly the calculation about what your resources are, et cetera.
How often?
But I agree.
So, if I may,
enough.
I'm sorry, I'm going to have to interrupt and just say this is an example of how we can get recommendations from your office and move forward with some solutions. So I'm going to say let's dig into that information maybe offline, and if we need to come back and talk about it, we can. All right, thanks. Representative Callaway, quick question, please.
Yeah, thank you so much. That was super helpful. My ears perked up when you said, and this is about SNAP. First of all, is this going to be presented to our Family and Children's Committee?
We can. Yeah,
Okay,
anything that's helpful on this information, happy to do it. We have it also available in report form for those who like to go through and just look at data. But I'm also happy to, anybody who wants to hear this information, happy to go through it.
I'm in both, so this is beneficial either way. But ineligible individuals receiving SNAP was 73 million. But that, you said, was not included in the error rate. So then what is included in the error rate if just strict ineligibility is not.
It's included in error rates, but the error rates are broken down into different components, and it's actually very confusing. So that's why we have that great big number that's all error rates, and that's the 84.60. That's everything all together, including eligibility, including overpayments and underpayments, and people who were removed who shouldn't have been removed. We have the ability to begin to pinpoint it a little bit. And actually, one of the things that we're working on, which I think will be helpful, and we haven't completed this yet, but one of our projects is to have a database so you can break down and see, if you want to see overpayments, underpayments, eligibility, so that way you can go and do that. It's actually one of our projects right now, and that might actually help you figure out, okay, how much is this, how much is that?
That would be helpful. So, but you are saying the 73 million is included in that 84.6 error rate.
Correct.
Okay.
Okay.
Correct.
Thank you.
All right. Senator Adams, we're going to, I've got speakers who are about to drop off the Zoom call. Are you good? Do you have a question that you need to? Okay. All right. Thank you so much. This was great. Really appreciate it. Okay. Next, we are going to turn on our Zoom, and thank you so much, Jim Bartell, for being here today. And I hope that your other speakers are still with us. This is an important topic, and I just wanted to give you a few minutes to be able to talk about compassionate access to medical cannabis, an act that you were successful in passing in a few states. And I want to give you some time to talk about the background and what this is. Welcome, and please introduce yourselves for the record.
My name is Jim Bartell. I'm Ryan Bartell's father. Joining me is Heather Manis, a registered nurse and executive chair of the Cannabis Nurses Network, nationwide organization of RNs, and Ken Sobel, who's a cannabis attorney. I will start just by saying, first of all, I've met with several of you on the committee personally, and I appreciate your time and your willingness to put this on the agenda. I'll just start by saying that Ryan worked in special education in Seattle with the Seattle School District, and he worked primarily with autistic children, and he was very good at it, and he loved his job. He was very effective with his students. On March 1st of 2018, Ryan called me and my wife to tell us that he had been diagnosed with stage 4 pancreatic cancer and had only a few weeks to live. I couldn't believe what I was hearing, and my heart sank and the tears swelled. He was in the hospital on his birthday, March 9th, and he died on April 21st, just 7 weeks after being diagnosed. What happened between March 1st and April 21st is why Ryan's Law was written. I did extensive research nationwide in all 37 states that allow cannabis to find out what they were doing to regulate the use of medical cannabis in hospitals. In Ryan's experience, in the first hospital, they had him on morphine, which wasn't strong enough, so they added fentanyl, which is 100 times more powerful than morphine, and all it did was put him to sleep. And so we asked the hospital if we could replace the fentanyl with medical cannabis. He said he would support that, but they had a hospital policy not to allow cannabis in the hospital. We worked it up the chain of command to get an exception. After 3 weeks, they said a final no. They would not allow it. So for 3 weeks, we had no communications, essentially, with Ryan. We found a hospital in Seattle that would allow medical cannabis. We transferred him, brought in the cannabis, gave him his first dose. He couldn't swallow anything at that point, not even water, so it had to be administered through a tincture under the tongue. He gave him his first dose, and he woke up the next morning, wide awake, pain-free. It was a miracle. And he immediately got on his phone and started texting his friends, "I'm awake, come and see me." Those last 3 weeks, he had 125 visitors, college friends, classmates, high school friends, family, of course. And so we did the research on hospitals in different states, and found that really nothing was on the books anywhere in any of the 37 states that would do what we wanted to do, and that was to require that all hospitals allow terminally ill patients to have medical cannabis for treatment or pain relief. So I wrote the bill myself. I had no connections in the state of Washington, but I do in California. So I got a senator friend to introduce it in California. It took 3 years, but we got it signed by the governor September 28th of 2021. It took effect January 1st of 22. It's been in effect for 3.5 years. There's been no lawsuits against it. All hospitals are cooperating. And it's actually been written up in the Oncology Medical Journal last year, being very effective and successful in California. So we are working in the other 36 states that allow it, and so far 11 more states have adopted Ryan's Law, and we have another 13 states that have introduced it. We're just waiting for it to get through the legislative process, and the remainder will be taken up next year in 2027. Our goal is to have it adopted in all 37 states by the end of 2027. So we did get a letter from Medicare and Medicaid CMS saying that they don't have any regulations prohibiting medical cannabis in hospitals, and the hospital would not lose their Medicare and Medicaid reimbursement funding if they did. Now, more recently, the president has introduced an executive order moving cannabis from Schedule 1 to Schedule 3, which has also helped us very much in terms of avoiding any opposition. So most of the hearings where I'm attending now have no opposition, and it's going very successfully in all the states we're working in. So, in conclusion, my happiest moments were in my life were each time I held each of my 3 children when they were born. The saddest moment of my life was holding Ryan's hand as he took his last breath. So I'm asking your committee to support a Kentucky version of Ryan's Law, so that my saddest moment is made less painful by ensuring that Ryan's Law will allow thousands of, if not millions, of terminally ill patients to live their final days with the quality and dignity that he was able to experience. Thank you.
Thank you so much, Mr. Bartell. I really appreciate your being here to share your story and Ryan's story, and certainly our hearts go out to you and to all the people like Ryan who are suffering with a terminal illness. And we're sitting up here having a conversation about whether or not we have real barriers to providing this care in hospitals. Now that we have a medical marijuana program here in Kentucky, I don't know, we're going to have to do our homework here, and we will. And we're going to find out what sorts of barriers there are in Kentucky. We're hearing in some hospitals that there are not. So maybe, obviously we're happy to look into this legislatively, but it sounds like some of the hospitals are adopting this practice anyway, which is good news because patients are able to get the care that they need, especially in end-of-life situations. So do you have any questions from the
Manager, the nuance to that is that really right now any hospital can provide that medication if the patient qualifies and wants it. But the problem is that some hospitals don't want to do that, and that's why they come up with policies like the first hospital that Ryan was in had a policy against it. So this bill is to avoid that conflict and to require that they allow it.
I see. Okay. All right. Well, thank you. I appreciate it. Do we have any questions from the committee? Nope. Well, we will make sure that everyone has access to the law that was passed, and we can take a look at it. We're going to certainly do our homework here and make sure that we are providing the care that patients need. So,
okay. Can we have Heather and Ken give a brief presentation also?
Yeah, we have a couple of minutes left. We've got one more presentation here, but if you would like to add anything, have your guests introduce themselves. Heather, I can.
Sure.
Heather, go ahead.
I'll be brief as well. My name is Heather Maness, and I'm a registered nurse. I'm the founder of the Cannabis Nurses Network, a national organization dedicated to empowering nurses through education and opportunity recognition and advocacy. And we've been working with Jim on Ryan's Law advocacy since the beginning. And we're really excited to see what has happened here in California, as well as the other states that have adopted Ryan's Law, in the fact that nurses are really the ones that are implementing this law. And the research that has been done is showing that nurses are satisfied and able and capable of implementing this law, and that the patient satisfaction, even more importantly, is there, that the patients are receiving the care that they feel that they need. I'm here today, obviously, in support of Ryan's Law, because no patient facing the end of life should be forced to choose between receiving healthcare and accessing a legal therapy that helps relieve their suffering. As nurses, we're guided by compassion. We advocate for dignity, patient autonomy, and the right of every person to receive care that aligns with their values and goals. For many terminally ill patients, medical cannabis can provide meaningful relief from pain, nausea, anxiety, insomnia, while allowing them to remain present with the people they love, just as Ryan was at the end of his life. Compassion shouldn't stop at the doors of healthcare facilities, and Kentucky does have this wonderful opportunity to ensure that patients spend their final days with greater comfort, dignity, and choice. And so on behalf of the Cannabis Nurses Network and the nurses we represent across the country, I respectfully urge you to support Ryan's Law. And thank you for your time and commitment to compassionate patient care.
Thank you so much. I really appreciate your work, and thank you for being here today.
On another note, we'd like to be a resource as well. So as you're working through it, if there's anything that our organization or myself personally can do to assist, we are here to help ease the process. So thank you so much.
Okay, thank you. All right.
Ken?
Yes, I'm not sure if you can hear me. I don't see my picture.
We can hear you. We can't see
Okay,
you.
very good.
Yes.
Well, you're probably better off not having to look at me for the next minute or so. But I'm Ken Sobel. I've been a lawyer for 50 years and practicing actively in the cannabis space for over 25 years, and have authored and written cannabis laws for states and regulations. And as Jim mentioned, I helped him write Ryan's Law after we did all the research on it. We helped create a safe harbor for hospitals to ensure that they would get their Medicare benefits, for any charges that were incurred. And just to reiterate that the importance of having a Ryan's Law is that we have to have some assuredness that a patient who's in Ryan's condition, who maybe only has a few weeks to live, isn't delayed from having the company of his family and friends by receiving the benefits that cannabis provides, in contrast to fentanyl, which has a heavy sedative effect, which deprives that patient, of having any meaningful quality time with his family. And I too am happy to spend some time. I know you adopted your program in March of 2023, and I can assure you, having done this research, that there's not a single state of the 40 or so states that have a medical program that have ever been challenged by the federal government on that, and nor would they likely do that as it relates to a Ryan's Law. And so I'm happy to assist you if you have any questions on that, and to also say that in a state or a commonwealth like Kentucky, your medical program, those medical facilities have already been reduced or made Schedule 3 by operation of law, according to the executive order that President Trump issued.
Okay. Well,
thank you very much. If you have questions at all, I'm happy to help. I've been a guest in Kentucky a few times and love your state, and so I'm happy to help if I can.
Well, thank you. We'd love to have you back. All right.
Thank you.
Well, thank you so much, and I appreciate your time today and, of course, your work. All right.
Thank you very much.
You're welcome. Okay, next we will hear a discussion on the Right to Try Act. So we have a few individuals here from the Goldwater Institute. I'm going to let you introduce yourselves for the record and give us the lowdown on the Right to Try Act. I know that there's some things happening nationally right now, federally, and what your proposal is. So,
Absolutely.
yeah, thank
Chair
you.
Mosher and also Chair Meredith. I know he had to get to a meeting earlier, but also members of the committee. Thank you for this opportunity. My name is Michael Frazier, and I'm a proud Kentuckian, and I also serve as the State Affairs Manager for the Goldwater Institute. I'm here joined by my colleague, Senior Fellow at the Goldwater Institute, Naomi Lopez. Kentucky has already demonstrated national leadership by enacting the original Right to Try Act. The law recognized a fundamental principle: when a patient is facing life-threatening illness and has exhausted approval treatment options, the government should not unnecessarily stand between that patient and the opportunity to pursue another path. Medicine, however, has advanced far more rapidly than our laws, as we know and this committee knows. Today, physicians can increasingly develop individualized treatments based on a patient's unique genetic profile, yet our regulatory framework was built for an era of mass-produced medicines and traditional clinical trials. The legislation that is proposed in the federal government, and also what we are proposing here before the Commonwealth, preserves physician oversight, informed consent, institutional review, and patient choice while modernizing Kentucky law to reflect the realities of 21st century medicine. It builds upon Kentucky's original Right to Try law and positions the Commonwealth to lead once again. And to explain the proposed legislation and what's going on federally, I'll pass it over to my colleague Naomi.
Co-Chair Mosher and Co-Chair Meredith and members of the committee, my name is Naomi Lopez, and I'm a Senior Fellow in Healthcare Policy at the Goldwater Institute. Thank you for allowing me to offer my public comments on the right to try for individualized treatments as you consider this important issue to protect the right to try to save one's own life without having to beg the federal government for permission to do so. I'd like to begin with the story of a little girl named Kira Riley. Kira was diagnosed as a baby with metachromatic leukodystrophy, or LMD, a rare genetic disease that progressively destroys the brain and nervous system. Her older sister Olivia had the same disease, but by the time her physical symptoms were discovered, treatment was no longer an option. Kira's story was different. Because her disease was diagnosed early, physicians knew there was a gene therapy that could possibly save her life. It wasn't designed for thousands of patients. It wasn't even designed for hundreds. It was designed for children like Kira. The problem wasn't the science. The problem wasn't her physicians. The problem was that our regulatory system was built for another era of medicine. It was designed for treatments intended for large populations, not therapies developed for an individual patient. As a result, Kira's family left the United States and traveled overseas so she could receive the treatment that offered her the best chance to live. No American family should have to leave this country to pursue a potentially life-saving treatment designed for their child. The Rileys' race against time to try to save Kira is what inspired us to craft the Right to Try for individualized treatments. Today, Kira is a thriving 6-year-old. She loves gymnastics, riding her bike, and doing all the things any healthy child her age would enjoy. But tragically, Olivia, who is now 8, is in hospice care. In many ways, however, this legislation is really the next chapter of a story that state lawmakers have already helped write. Kentucky lawmakers are already familiar with the original Right to Try movement. Beginning in 2014, states across the country recognized that patients facing life-threatening illnesses sometimes had exhausted every approved treatment, yet still could not access investigational therapies that had demonstrated sufficient safety to enter clinical trials. States acted first. 41 states ultimately acted Right to Try laws. Congress followed, and in 2018, President Trump signed the federal Right to Try law. It remains one of the strongest examples in healthcare policies of states leading and the federal government following. But medicine continues to advance rapidly. Today, we can increasingly identify the precise genetic mutation causing diseases, and in some cases, even develop a treatment tailored to that individual patient. These therapies don't always fit within the traditional clinical trial framework because they aren't intended for hundreds or thousands of patients. Sometimes they are only intended for one. Our regulatory system, however, still treats those therapies the same way. That's the gap this legislation is designed to address. Consider that 95% of the more than 7,000 rare disease and ultra-rare diseases that have been identified lack an FDA-approved treatment. About 80% of these diseases are genetic in nature. The original right to try law was a tremendous step forward, but it was written before many of today's individualized therapies existed. And as medicine has advanced, our laws must advance with that. Right to try for individualized treatments does not replace the original right to try law. Instead, it builds upon its success. The original law remains available for investigational drugs that have entered clinical trials. The legislation but this legislation, the right to try for individualized treatments, creates a separate pathway for individual investigational treatments for patients with life-threatening or severely debilitating diseases who have no satisfactory treatment options. Like the original right to try law, it is built on patient choice. Participation is entirely voluntary. No patient is required to seek treatment. No physician is required to recommend or provide it, and no manufacturer or facility is compelled to participate. For those who choose to do so, the legislation preserves physician oversight, informed consent, institutional review, existing standards of professional accountability, and existing liability protections. It simply modernizes the law to reflect advances in medicine that were unimaginable when today's regulatory framework was developed more than 50 years ago. States are leading once again. Nearly 20 states have already enacted right to try for individualized treatments or similar legislation. And earlier this summer, legislation was introduced to Congress to establish a federal pathway for right to try for individualized treatments as well. So this raises an obvious point. If Congress is considering this legislation, why should Kentucky act? I believe that there are 3 important reasons. First, state leadership creates momentum for federal action as it did with the original right to try law. The original law succeeded because states demonstrated that patients deserved another option, and Kentucky has the opportunity to help build that same momentum again. Second, state action provides insurance against congressional delay. Patients with rare diseases cannot always wait for Congress. State leadership helps ensure that patients are not left behind while Washington debates. And third, this legislation represents an economic development opportunity. The next generation of medicine will increasingly involve gene therapies, cell therapies, genomic medicine, and individualized treatments. States that welcome responsible medical innovation are more likely to attract research, investment, manufacturing, physician expertise, and clinical partnerships. Healthcare policy and economic development increasingly go hand in hand, and Kentucky has an opportunity to lead on both. Like the original right to try movement, this legislation doesn't lower safety standards. It is about modernizing a legal framework that was written before today's medical breakthroughs were even imaginable. The original right to try movement showed what happens when states lead. Patients benefit, and then Congress follows. Kentucky lawmakers have the authority as well as the legislative vehicle to unleash the potential of today's medical innovations to further benefit patients. Thank you for your consideration of this important reform.
And thank you, Naomi. Again, the Right to Try 2.0 has been enacted by 18 states. And, even though that it's been introduced congressionally, the State Act actually ensures that there's greater protection within liability because you all define what is the cause of action. So while we're able to help those who are in need currently, we're able to also ensure that we protect against medical liability and ensure that patients get the access to care they need. And for as many of you all know, my mother is currently undergoing treatment for stage 4 triple-negative breast cancer at St. Joseph at Mount Sterling. Triple-negative breast cancer is one of the most aggressive forms of breast cancer because it lacks the receptors physicians typically rely upon for her targeted hormone and her HER2 therapies. As a result, patients like my mother have significantly fewer treatment options. And when the disease has metastasized, every advancement in medicine represents another opportunity worth pursuing. I've spent many hours sitting beside my mother at an infusion center. When you spend that much time in a room with people who are literally fighting for their lives, and I know as many of you all have done, many of you all in the healthcare profession, first responders and service industries, and in your profession, it becomes deeply personal. Every person in that room is hoping for one more treatment, one more breakthrough, and one more chance. I witnessed firsthand the hope that medical innovation can inspire. One afternoon, when patients were receiving their infusions, I was with Mom, and a commercial from a Kentucky cancer center came on the television. It featured a patient climbing a rock wall, discussing that she wouldn't be here without a breakthrough cancer care, and concluded with the message, "The impossible doesn't live here." As the commercial played, I watched patients throughout the infusion center stop what they were doing and turn towards the television, and for just a moment, you could see the hope spread across the room. In a place where every patient was fighting for more time, they were asking, can we have that promise for another chance and another opportunity to try? That moment has stayed with me because it reminded me that patients confronting life-threatening illnesses are looking and deserve the opportunity to preserve the next medical breakthrough when science makes it possible and when their physicians believe it to be appropriate. And although while that treatment described in the commercial may not have been available for those patients, legislation like Right to Try 2.0 helps ensure that when the next breakthrough becomes possible, Kentucky patients have every lawful opportunity to pursue it rather than wondering what might have been. That's exactly what Right to Try 2.0 seeks to provide. The legislation does not promise miracles. I'm not a miracle worker, and we're not trying to offer miracles. That's not the business we're in. Nor does it guarantee a cure. It does not require a physician to recommend treatment. It does not compel a hospital to administer it. Nor does it require a manufacturer to manufacture it. What it does recognize is that when legitimate scientific innovation creates a potential opportunity, neither federal nor Kentucky law should unnecessarily prevent a patient working alongside his or her physician from pursuing that opportunity and exercising the right to try. To be clear, my mother is at the point where she likely would not qualify under this legislation. She's at the point in her health stage where that's more of a dream than anything. But because today's science has not reached that point for her disease, that doesn't mean that we should stop others. I'm talking about another family circumstance, maybe different, and I hope and pray that it is. Another mother, another father, another spouse, or another child may have an opportunity for an individualized treatment available that offers a genuine fight, an opportunity to try another chance. You all already know this, and I'm so thankful for your work because Kentucky has helped lead the nation when it enacted the original Right to Try Act. And today, the Commonwealth has the opportunity to lead once again by ensuring our laws keep pace with modern medicine and continue to put patients first. And while we cannot guarantee a cure, we can ensure that Kentucky never stands between a patient and a scientifically supported opportunity to fight for his or her life. Again, thank you for your time and consideration. Naomi and I are pleased to answer any of your questions.
Thank you so much for your presentation. This is very interesting, and I think something that we should do more homework on. So thank you. We do have a couple of questions. Senator Burke.
Thank you. Thank you for a wonderful presentation. Thank you for letting me ask so many questions. Who pays for these therapies? I mean, I'm assuming that they're not covered by insurance since they are outside of the normal realm of medical treatment. Is that correct?
Chair Mosier, Senator Berg, the law as it's written is written in terms of payment the exact same way that the original Right to Try law was written, in that no one is compelled to pay. So insurers are not required to pay under this law. We do know from the original Right to Try program that in some cases insurers do pay. The first publicly treated patient under Right to Try. He was not the first, but he was the first publicly treated patient. He received his treatment through the VA. There were patients who were treated for neuroendocrine cancer in Texas by Dr. Ibrahim Dalpasan by Medicare, and in fact, some of the leading research facilities and treatment centers around the country were sending their patients to Dr. Dalpasan in Houston, who treated about almost 200 neuroendocrine cancer patients under that state Right to Try law before it became federal law. And we also know from the first public Right to Try program for glioblastoma, which provided Right to Try in a phase 2 clinical trial with the addition of an additional, it added an additional medicine to that treatment, actually surpassed the results of the phase 2 for the drug that was being trialed. And in fact, it was so successful that that treatment, by request of the FDA, by request of the FDA, was actually accelerated into phase 3 into fast track approval process. So we know, and under that one, we know that there were insurers paying as well. So under the way the law is written, no insurer or payer is required to pay, but they are allowed to, and we know that they do in some cases.
Follow up. I have a concern in that you're basically developing a system where people who have all the money in the world can buy whatever hope they want, and people that don't get that chance. And I'm also a little concerned that there are bad actors who will take advantage of people's desperation to their deathbed. And I don't know how we stop that in this realm.
Chair Mosier, Senator Berg, those are really important questions, and I'm glad you raised them. So under this, so in the world and in our country, unfortunately, the patients who have medical expertise and knowledge, or who are well connected, or who have more resources, do travel to other countries to obtain treatment. And it's those who don't have the knowledge or expertise or the resources that stay here. And in some cases, patients who are incredibly desperate will go to places where they probably aren't offering treatments that are safe or effective, and are preying on, unfortunately, on patients. So under the Right to Try for individualized treatments, we have multiple layers of protection for those patients. The regulatory and rules model for this law is guided by the federal Department of Health and Human Services. They have an Office for the Protection of Human Research Subjects, and there's a set of laws called a federal-wide assurance, which requires that facilities that would be participating in this have multiple layers of protection in addition to what's outlined in the law specifically. But the federal-wide assurance are the facilities that have said we are complying with these sets of rules, including an institutional review board, including registration of that institutional review board with the Office for the Protection of Human Research Subjects, with informed consent. So there are multiple layers of protection. And what I would say is, unfortunately, we do live in a world where there are bad characters, but because you have the authority to pass this law and establish this framework, you are actually helping to prevent people from being preyed on as much as they might otherwise.
And just one comment is that, the state proposal also incorporates those same guidelines and also requirements. It parallels those to ensure that we do protect patient safety. And I know that many of this committee, including your work, Chair Mosier, and everyone here, is to ensure that we have equitable access to healthcare and quality healthcare. That's part of the reason why we're making the state proposal, is because, y'all, as you know, I'm just a kid from a trailer in Powell County, Kentucky. I don't have $50,000 to take my mom somewhere or somebody else to do the same thing. So that's the reason why we're also offering the state program, is to close that gap in equitable treatment and also safe treatment here, instead of going to Mexico and doing things that people shouldn't be doing, which, again, I heard in desperation in these infusion centers, people considering, and you're absolutely right, Senator, people do, in desperation, do consider that.
All right. Well, thank you so much. I appreciate your presentation. I know that you made available the proposed legislation, right, to everyone. I think that's
Yes, ma'am.
Okay, so everyone, feel free to take a look at that. We know where to find you if we have questions, and I think this has been a really good discussion. Thanks for sticking around so late. I appreciate it. And everyone, a lot of people left without getting cupcakes, so get over here. All right, I know. Okay, all right, thanks. Okay, well, seeing no further business before us, we will miss Deanne greatly, and DJ, by the way, is moving to a new department, and congratulations to you. We're going to miss you too. So, I know. So, well, I know. Thank you. All right. See no further business. We are adjourned.